Do I need to explain that further? Because you said you don't understand.
Yeah,
about the deny or admit liability.
I said I am aware what you are saying, but I do not understand. Do you understand what I'm saying?
Okay, what is it that you don't understand? So I can maybe help you
So maybe I need to
process.
clarify that I'm here under special appearance today.
Special appearance in
The
what
special
sense?
appearance as a living woman, naturally born woman, one of the people, American state national. I'm not subject matter to the rules of civil procedures.
Alright, buckle up, because today we're diving back into one of the most fascinating sovereign citizen meltdowns you'll see over a grand total of $43. Yes, you heard that right. A $43 parking ticket has now evolved into a full-blown jurisdictional battle featuring land patents, American state nationals, contract law misunderstandings, and a mysterious man named Mr. San Clemente. If you remember Lenka Coloma, she's the self-declared sovereign who previously tried to pay this exact parking ticket using a £5 British commemorative coin, because apparently international novelty currency now settles municipal citations. Today she's back. And this time she's attempting her first formal appeal. But here's the twist. Instead of simply arguing whether the ticket was valid, she's challenging the very authority of the city to issue it. She's not understanding, because she refuses to stand under. She's not driving, she's traveling. She's not a defendant, she's appearing specially. And as this hearing unfolds, you'll watch the classic sovereign strategy collide with a calm hearings officer who's just trying to determine one simple thing. Was the car parked there illegally or not?
So according to
let me just finish.
Sure. I'm sorry.
I'm also a secured party creditor and attorney in fact for Lenka Coloma spelled in all capital letters for my trust.
Okay.
Do you understand what I'm saying?
I understand that there's other designations that you've claimed that you have for this hearing.
Yeah, it's
Whether
on
or not
record.
that's going to bear on the case, I have no idea.
All right, excellent. So I just wanted
But
to
you
put it
don't.
on the case.
So you're saying you do not understand what it means
I
to.
do not stand under your jurisdiction of the rules of civil procedures or anything you were trying to make me to basically be under. That's what that means.
And here we go, right out of the Sovereign Citizen Playbook. Special appearance. Living woman. American state national. These phrases aren't random. They're part of a broader strategy intended to challenge jurisdiction before the court can even address the underlying issue. The theory, at least online, suggests that by declaring yourself outside federal or municipal authority, you can avoid statutory enforcement. But here's the critical point. Jurisdiction in a municipal parking case isn't determined by how you describe yourself. It's determined by where the alleged violation occurred and whether local law applies. And if the car was parked in San Clemente, California, then California law governs. Period. Notice what's happening strategically. Instead of addressing whether she violated parking regulations, she's attempting to redefine her legal identity. It sounds powerful. It sounds assertive. But in practice, it rarely changes the outcome. The hearing officer isn't debating metaphysics. He's evaluating a citation.
So at this time, you can make your plea of either admit or deny liability.
Okay, excellent. So first of all, so when I received the ticket,
I'm going to let you go ahead and get into
Yes,
that,
yeah.
but I need you to tell me whether or not you deny or admit liability. That's what
if I admit or deny liability,
doesn't-
Bill, can you advise me on this, please?
Well, the question is not whether you were parked there, the question is whether or not you got the ticket.
That's right.
And you did get the ticket,
Yes,
so it's okay, you can acknowledge you got the ticket.
Yeah.
Okay, so you
I received
admit-
the ticket, yes.
Yeah, right, okay.
Okay.
So with that, I'm going to turn the floor over to you, and you can share with me
Okay.
your reasons for contesting the citation.
Okay, excellent. So I parked my automobile at the North Beach in San Clemente. I was there maybe like 30 minutes or something, and I come back. Yeah, and there was a ticket on my private automobile. And so, because I'm a private American and because I'm fully aware that this is an American land, which by the way, is secured actually under land patent, okay? I have actually a certified copy in my office. So I was not surprised by receiving this ticket because it's obvious a trespass on my private property.
This moment is subtle but important. She's asking the hearings officer for guidance on whether to admit or deny liability, while simultaneously rejecting the legal framework he operates under. That contradiction is central to many sovereign citizen encounters that if you reject the authority of the system, you can't simultaneously rely on that system for strategic advice. The hearings officer can clarify procedure, but he can't provide legal counsel. And asking him how to plead, especially while arguing you're not subject to civil procedure, undercuts the jurisdictional argument she just made. That it highlights a common tension, the desire to challenge authority while still engaging with it. But courtrooms operate on defined roles. The officer's role is to determine whether the citation stands. Her role is to present evidence or argument relevant to that determination. The more she drifts into abstract theory, the further she moves from addressing the actual ticket.
So I wanted to resolve it in a pretty fairly, quick manner. So I sent the ticket back
I've looked
with
at that.
refusal that I refused the contract, and I reserved my 72 hours to rescind under the contract law, and that I invoke my rights as private American, one of the people, and all my rights are reserved under UCC 1308 without prejudice.
Now this is where things get interesting. UCC 1-308 absolutely exists, but its application is routinely misunderstood in sovereign circles. The Uniform Commercial Code governs commercial transactions, not parking enforcement. Invoking all rights reserved doesn't create immunity from statutory obligations. It preserves objections within the context of contract law. The key difference? A parking citation isn't a negotiated private contract between two equal parties. It's a regulatory enforcement action based on municipal code. There's no mutual agreement being formed at the moment the ticket is issued. So writing UCC 1-308 on paperwork doesn't transform the interaction into a commercial dispute. And this is where many sovereign arguments collapse. They correctly identify real legal provisions, but misapply them to contexts they were never meant to govern. It sounds technical. It sounds authoritative. But legally, it doesn't move the needle in a municipal citation hearing.
Okay, so I actually came here directly on December 4th, when was it? December 14th? No, January 4th, right after the holidays, to settle the matter. There's actually a video, everything was videotaped, and I came to settle the matter. I wanted to meet with the party that issued the ticket, Mr. San Clemente.
I
And
don't know if there's a Mr. San Clemente, the city
oh,
of
well,
San Clemente.
all right, well, now we have a problem, right? Because someone issued the ticket, right?
Yes.
And so I wanted to meet with the man or the woman who issued the ticket and find out that they have a contract with me. Well, no one could find Mr. San Clemente, right? So I said, all right, well, now we have that we have one issue because we don't have an actual claimant.
Here's another foundational misunderstanding: the assumption that a government action must be based on a private contract. Municipal authority doesn't derive from individualized contracts with residents. It derives from statutory authority delegated through state law. When she asks to meet Mr. San Clemente, she's framing the city as though it were a private claimant in a commercial dispute. But legally, the claimant is the municipality itself. There doesn't need to be a specific person who personally contracted with her. Parking enforcement is an administrative function, not a handshake agreement, and notice how the hearing officer stays focused. He doesn't engage in philosophical debate. He redirects to evidence. Was the vehicle parked there? Is there testimony otherwise? That's procedural discipline. He's narrowing the scope back to what matters for the ruling.
But anyway, and in order to come to sit down with you, I was forced and intimidated to pay that ticket, which actually to, not even to pay it, right, to give you guys, under duress, $43 FRNs, right? I actually offered to pay the alleged debt, even though we never discovered Mr. San Clemente, and that was denied.
I appreciate all that information and the course of events to get to this day and this appointment, in this hearing. But I'm here to listen to evidence that would be used to potentially dismiss or confirm that the citation was issued properly. Okay, so,
Well,
so far,
okay, so I
it's
have-
your floor, so just
Yes,
provide me
so
the
I have,
evidence.
the first issue we have is, who is Mr. Samplementa that walks around and issues ticket to private Americans? Second problem is, where did this Mr. Samplementa, that's pretty much non-existent, took an authority to put meters there on our private American land that belongs to we the people, okay, to coerce and extort money for a very long time, by the way. I've been living here for some 30 years.
This is an emotional escalation. Now we're hearing words like intimidated, extorted, lawful money not accepted. Emotionally powerful language, but legally specific claims require evidence. The earlier issue with the British commemorative coin matters here. A municipality is not required to accept foreign commemorative currency as payment for a local citation. Legal tender laws apply to U.S. currency for debts, but even then, procedural payment rules still govern how fines are processed. What we're seeing is a reframing of rejection into grievance. Instead of addressing whether the payment method complied with policy, it becomes a broader claim of rights violation. That rhetorical escalation may feel compelling, but in a structured hearing, the officer is bound to measurable standards, not emotional framing.
Third of all, how come I come here and I'm coerced and intimidated, lawful money is not accepted, and I'm extorted furthermore to pay you in legal tender to actually get a hearing. Also, the other thing I wanted to tell you, so let me just finish, okay? I don't know if you
That's not my
understand.
role. I'm here to just simply.
Right.
Your
And
reasons for
listen,
contesting.
I know that you are a good man, okay? This is our discussion between women and men, okay? And we have
Well, actually,
certain laws.
respondent and hearing
Okay.
officer.
So with my further research, I did find City of San Clemente online,
Okay,
okay? You know who Mr. City of San Clemente is?
no idea.
It's a corporation.
And now we enter the classic traveling versus driving distinction. The argument typically hinges on narrow federal definitions of motor vehicle tied to commercial activity. But as the transcript explains, state vehicle codes define motor vehicles independently for regulatory purposes. Jurisdiction in this context is state-based. If California's vehicle code defines a motor vehicle as any self-propelled vehicle, then that definition governs within the state's regulatory authority. Federal criminal code definitions don't override state administrative enforcement for parking violations. This is another pattern, selectively citing federal language while ignoring state code. But municipal citations rely on state delegated authority. If the car is self-propelled and parked in a metered space, the relevant definition is likely already satisfied. Redefining words doesn't redefine statutory applicability.
Was issued
Well-
correctly or not?
We have a bigger issue now.
Okay, so
Do
you
you
have
realize-
a room full of witnesses.
Yes.
Are any of these witnesses here to tell me that your vehicle was not parked there? Were they
It's
to
my
tell me
automobile.
your automobile?
yes.
Is anyone here can?
Point of clarification, you made a mistake when you brought up the word, who got the ticket. You said you got the ticket, and Blanca answered that question, but the law is black and white, so you need to define the word you, proper syntax, because Blanca is not a you.
So is anyone here to say that the vehicle was not parked there?
No.
Well, I have a little bit of an objection. It wasn't a vehicle.
Okay.
A
what was it?
vehicle is a commercial term, and this is not a commercial item. A motor vehicle specifically is defined as a self-propelled contrivance used to carry passengers or product or cargo for hire. She's not for hire, so she's not commercial, and so it's not a vehicle.
And this is where the reality of the process becomes crystal clear. The hearings officer clarifies his role. He's there to review the citation and make a determination, not to debate constitutional philosophy, not to disclose bonds, not to litigate global jurisdictional theory, just to evaluate whether the parking citation was properly issued. Throughout this hearing, Lenka consistently shifted the focus from the factual issue, was the car parked in violation, to abstract arguments about identity, contracts, and jurisdiction. But administrative hearings are narrow by design. They operate within defined statutory boundaries. This case illustrates a broader lesson. Quarter.
Okay, my role here is very simple. It's very rudimentary. It's here to, I'm here to listen to your reason for contesting the citation. And so that's what I'm here to do. So if no one has any other testimony in regards to what the issue is at hand, then that's fine.
Yes, I have more to say, although I'm not sure it's appropriate at this time.